Okay, so all of those rules apply when you get your case. And those are things that you need to take into consideration when you're presenting your case. When you get your case, you're going to get a bunch of stuff, about this much. And it may be a little bit overwhelming. It's going to include a summary of the case, which is basically an overview of this is what the case is about, this is the factual scenario that you're going to be trying to talk about as you go forward with the case. Then, if it's a criminal case, you're going to get a criminal information, which is essentially the charges that are being asserted against the defendant. You're also going to receive a pretrial order, and that gives you information about who the witnesses are for each side. It also gives you information about the exhibits that are available for each side, and the stipulations, which are items that the parties have agreed to. So you don't have to necessarily present that evidence at the time of trial because there's no objection to it. But you need to understand what those items are so that you don't spend time covering material that there isn't really necessarily an objection to. You're also going to receive jury instructions and a verdict form. The jury instructions is what's going to tell you what you need to prove during the trial. It will show you the elements of the case that you need to establish. If it's a negligence case, it will tell you that you must establish duty, breach of that duty, and liability for damages. If it's a murder trial, it will give you what has to be established in order to show felony murder or manslaughter, different things like that. So those are the things that when you get to your witness statements, you need to be looking for who can actually provide testimony that addresses this element that I have to prove at the time of trial. The jury instructions will also establish who has the burden of proof to present what during the trial. Either the prosecution has to prove that the defendant is guilty of the crime, or if you're the plaintiff, you have to prove that the defendant is liable for damages and owes you money. You will also get 6 witness statements. There'll be a witness statement for each person who's going to testify at the time of the trial. Those statements can be fairly lengthy, and for each person who's going to portray that witness, they need to be extremely familiar with the content of their statement. At the same time, there's information in here that may not necessarily help to prove something in your case. So you need to decipher what's important and what isn't important out of those witness statements. There's always going to be some things thrown in there that are just thrown in there to see what you guys will do with them and how you will use them and whether you'll realize that you don't need to use them. So you need to be looking for that when you go through your witness statements. In addition, your witness statement isn't the only thing that talks about you. If I am the defendant, and the case is about whether or not I killed someone, other people have things to say about what I did and when I did it and where I was, and I need to be aware of those things because what I have to say about that, in most instances, is not necessarily going to agree with what everybody else says I was doing at that point in time. So you need to review your own witness statement, but you also need to review the other witness statement so that you know what other people are going to testify about you. Because if you know, then you can have a plan for how you're going to respond to questions about that. Well, so-and-so says you were here, so weren't you really at this location and not that location? Those are all things that, as you go through your materials, you'll be able to start to address. In addition, you're going to get a series of materials that are exhibits to be admitted at trial. Most of the time, you need to be trying to get into evidence as many, if not all, of these exhibits as possible. You need to make an effort. You get points for making an effort to introduce these exhibits. And if you successfully introduce them, then you get more points for being successful at it. In addition, when you're going to use exhibits, though, you need to think about who actually knows about this exhibit. Whose statement has information about this exhibit that reveals that they actually have personal knowledge of the location that's being portrayed or the material from the police report or whatever the item might be. So just because you have exhibits, they are not capable of being introduced through every witness. There's only going to be 1 or 2 witnesses who are going to be capable of giving testimony and getting that exhibit into evidence. And so you need to plan ahead. This witness, this exhibit, I need to try and accomplish that during the course of my direct examination or cross-examination so that I can make sure that I get all my evidence in. Now, once you receive the case, obviously you want to read it all. Sometimes you'll also receive statutes or cases, and that is to kind of give you some information about how to use the information that you're being presented with. What kinds of things do you need to establish? It will give you some background about how to proceed with the case. It will also give you some input on things that you might want to discuss during closing when you're allowed to present arguments about what the law is or isn't. This is also the time when you're first reading through these materials that you need to start thinking about themes, things that you can use to tie through the entire trial, a big idea that you can kind of start drawing in your jury with and say, this case is going to be all about greed, it's going to be all about doing anything you can to get where you want to be. Whatever your theme is going to be, and we'll have more discussion about that momentarily, this is the time that you need to start developing that. When you first start reviewing the materials, you need to be thinking about, okay, what's the best way to present this? What is our story going to be? How are we going to pull this together so that a jury can follow it and understand it? So those are the main materials that you're going to get. In addition to that, you're going to have the rules of competition. You'll have a hard copy of the rules of evidence that are to be utilized in presenting your case. And then you'll also have access to a variety of materials, including the mock trials, preparing, presenting, and winning your case. This is a detailed, essentially, how-to guide for mock trial. And if you have, everybody should have access to it or will have access to it. And this kind of gives you a way, especially for schools who are new to the program, there's an entire section devoted to opening statements, an entire chapter. There's an entire chapter devoted to direct examination. There's an entire chapter on rules of evidence that will give you some information about how to process all of this information that you're being given. In addition to that, you will also have the Articulate Advocate. And this book is more about presentation, because it's not only about the information that you give and the facts that you give, but it's also about how you give them and your public speaking skills, if you're a witness, your skills as far as being dramatic and being able to get into that role and be convincing that, yes, I believe you are a physician with 20 years of experience because of the way that you present yourself and the speech that you use and the way that you can explain how much experience you have and why you've reached the conclusions that you've reached. Those are all the things that make a difference as you get into the actual having the judges look at you and evaluate you and give you scores.